This is our last section of notes for the year. It's actually a very short section. There's a lot of things in here, but most of this we have actually covered. Again, it's a very brief overview of what the civil rights, with the history side of this. A lot of court cases, which we have already covered along the way. So that's where you see, and it's just kind of putting it all together with it. I save it for last because of where we finish the court cases. One of the things that you have to look at here, and you see this quote from James Madison from Federalist 51, basically saying about how government's necessary. In many ways, it's kind of like in the beginning of the year where we had Hobbes, that Hobbes said that government is necessary because people are beasts. He's a little nicer with it, saying that people aren't angels. All right, for civil rights, this is where definition to guarantee that people are not discriminated against. Their race, religion, gender, origin, sexual orientation. The key amendment to know is the 14th Amendment, and there the Equal Protection Clause in there. So that is where the states cannot deny any person within its jurisdiction the equal protection of laws. Now, here's a key thing to remember where we had the civil liberties before. Civil liberties focus on the individual rights and basically to make sure that the government doesn't overpower. Civil rights is a group's rights that is usually protected by the federal government. For our history, when it comes for slavery, slavery was in the original Constitution. The Slave Trade Compromise, Three-Fifths Compromise, that was part, then again, of the original Constitution. For the first 80 years of our country, we prolonged the issue of slavery by compromise. Here, again, that's more the history side. For our third parties, remember we had the third parties quiz. Two of the third parties you had to know were Liberty Party and the Free Soil Party. And they're great examples of where a third party comes about because of an issue that the major parties aren't covering, in this case slavery. And then the major parties will adapt it. This is where the Republican Party, when it forms, will take in people from the Liberty Party and especially the Free Soil Party. So in your writing, if you have one of the things that was given as a thank you to Free Soil Party that didn't want slavery in the territories, they wanted it free of slavery, but they also wanted the free land. And the Republicans will pass the Homestead Act in the middle of the Civil War. The Dred Scott case shows that where slavery was in the Constitution, because that's where Dred Scott was not given the rights of a citizen. But the 13th Amendment will outlaw slavery that we have. So our next time period we get to after Reconstruction will be with Jim Crow. After the 13th Amendment bans slavery, we will have black codes throughout the South. And these are laws that said if you're black, you can't do certain things. You can't move without permission of the mayor. You can't own land. You can't have a weapon. This will be the impetus for creating the 14th Amendment there. Now, the 14th Amendment, this is where, once it was passed, the South will pass the Jim Crow laws, which we will have in that dual sovereignty time period there, where the Plessy versus Ferguson backs up the Jim Crow laws, but they are supposed to be equal there. The South kind of forgot that equal side of this. For our interest groups, the NAACP is formed by Du Bois after the Niagara movement. This will be the leading interest group for African American movements in the 50s and the 60s, as well as one of our top interest groups today. Fast forward to Brown versus Board of Education, and this is where segregation was seen unconstitutional in public facilities because it violated the Equal Protection Clause here. Now, key part that we said when we went over this case, that the problem was they said that with all deliberate speed did not give a time for it. Civil rights movement of the early 50s, the early 60s, for your U.S. history, remember both the civil disobedience side and thinking Martin Luther King, as well as the more violent side, like the Black Panthers side that you have. Two laws, well, there's three civil rights laws you must know. Civil Rights Act of 64, Civil Rights Act of 68, and the Voting Rights Act of 65 that we'll get to. But the history side, make sure that you know Civil Rights Act of 64, it outlawed de jure. De jure means by law. Here, this is where the South had official legal segregation. Meanwhile, a lot of the segregation in the North was by custom, and that's what the 68 Civil Rights Act focused on, was de facto segregation. And for our court cases, remember the Heart of Atlanta Motel case. It will expand upon Brown versus Board and will even bring it into certain private areas such as hotels and restaurants using the Interstate Commerce Clause that we have. All right, other civil rights things, government connections that you need to know. Baker versus Carr. We had this case earlier this year in the voting. The one person, one vote I did. This is where it takes place in Tennessee, where each county was given the same amount of vote, even if it was a tiny rural county or it was a county that included someplace like Memphis. What ended up happening is for African Americans that were higher in the cities, they were not being representative. Notice that word malapportionment. When you see mal in front of something, usually it means bad, so bad apportionment. The 24th Amendment, when we had amendments, told you that that is one of the ones that the College Board loves because it makes a lot of categories off there. So it's an amendment, it deals with voting as well as it deals with civil rights. So make sure with the outlawing of the poll taxes there in 1964. Next year later will be the Voting Rights Act in 1965. It will allow federal intervention. It takes a lot of those things that were done before that the South had that was trying to stop some of the voting from taking place. Now for the Swan case, again another case that we had, Swan backs up Brown versus Board of Education, and this is one that will allow busing to take place there in order to try to achieve the goals that were in Brown. Now, a lot of African Americans in the South will have their first time of being able to vote in 1964, more in 66, but a lot of them it was 1968. And this is where you'll see the effects of, first of all, the outlawing of the poll taxes, and then the Voting Rights Act taking place there. All right, for the women's movement, historical side of this. 1840s, we hold the Seneca Falls movement, the Declaration of Sentiments as written, but the women will be convinced to help with the abolition movement, and they were promised that as soon as the slavery was ended, that the group of men would work to help give them the right to vote. Well, they didn't quite keep their promise, although after a half century later, they will. So we have our suffrage movement and our 19th Amendment, and for what is historically the second feminist movement there. So women will gain the right to vote in 1920. During the 20s, we will have a push by Alice Paul for the ERA. It will fade away. It'll come back in the 1960s and the 70s, but the ERA will never be passed there, the Equal Rights Amendment there. During World War II, when women will, because of an executive order, be paid equally but with wartime industries there. But when the war ends, they are no longer making equal pay there. But the Equal Pay Act of 1963 will guarantee equal pay by job in government jobs, again, not in the private sector in this case. The Civil Rights Act of 1964 will have the Title VII provisions that have to do with women. A lot of times we think only for African Americans, but there are things for women. We're going to have 1973 Title IX Act that was also passed later on. Historically, book to remember is the Feminine Mystique, which soon after that will be the formation of NOW, which is when we did interest groups, our largest interest group fighting for women. Here's where we have cases that you don't have to know them off the top of your head, but know the general ideas that you can't ban classifications by gender, and the one where for Goldberg in there where it said that only men could be drafted there. All right, a lot of times we kind of forget about other minorities and we kind of focus on African Americans and the rights they made, and with women also. Hispanic Americans may not have had early on as many leaders like a Martin Luther King Jr., although you see there Cesar Chavez there. And this is where for Hispanic Americans they've had a lot more organization in recent decades here. Interest groups, remember the Urban League, when we see for a distinguished gentleman, some things happen with that. A court case you need to be familiar with, and notice the date on it's 1954. Hernandez versus Texas, and one time there was an AP question that they had, and they had a short reading on that, and once you read it, you would realize that they were banning segregation for people that were Hispanic. Same year as Brown versus Board of Education, so it was saying not just for African Americans in that case. Native Americans, our first group, are some of the ones that got some of the less rights. This is where, for our bureaucracy side, remember that the Bureau of Indian Affairs is part of the Department of Interior, and just recently we will have our first Native American that is the Secretary of the Interior. So the first time that the Bureau of Indian Affairs will actually be headed by a Native American. Asian Americans have not had as much organization long term. This is something that has been occurring a lot more. Also, Asian Americans becoming more active in voting. A lot of the cultural sides had made it where Asian Americans do not like the more competitive side and sometimes vicious side that we have partisan-wise, when there's more from a collective spirit. But there has been a lot more organization and also activity of Asian Americans in the last 2 decades there. All three of these groups, when we start breaking it down party-wise, and we go back to our voting, all three of these groups tend to vote for the Democratic Party. But remember, when we're voting, don't just go with Hispanic Americans and make a blanket statement for them as we start breaking apart. Mexican Americans are more likely to vote for the Democratic Party, but Cuban Americans, people that are from Colombia or Venezuela, are more likely to be Republican. And even that, some of it's changing, because even with everything that Donald Trump had done, he actually had gained vote within the Hispanic population, and even in some areas like South Texas, the Mexican American population, Native Americans and Asian Americans tend to vote Democrat too here. Other groups that you need to kind of look at and see that we have covered throughout this year for various things. The disabled, that is considered a minority group. Remember when we had the Americans with Disability Act, when we were talking about unfunded mandates there, which say you can't discriminate against them. Older Americans, I know you feel like they get a lot of special privileges, but sometimes there are things that they are discriminated against. The graying of America, the idea that we're getting older in here. That's why we have our issues with Social Security, Medicare. Don't forget, with interest groups, the largest interest group in numbers is AARP. We have several different cases that we've looked at there with for homosexuals, the Bowers case in here. But this is where, and in Oberfeld versus Hodges is one, and in our readings where I gave you, or if you're in class today, I gave you the list of the 10 different court cases with little summaries of those. We had government-wise for a long time, from Clinton through Obama, our official government policy for the military was don't ask, don't tell. The military officially said you were not allowed to be homosexual, but we had that kind of little caveat in there. Obama, by executive order, will take away the rule that banned homosexuals from the military. With our different court cases, you will see how that students that gained some rights in the 60s, that will change in the 1980s and the 1990s. There, you think the Tinker case with the idea of symbolic speech against the Vietnam War, but then later on Bethel and Hazelwood, and the idea of in loco parentis that you would have. All right, affirmative action. Now, the idea of affirmative action was to give historic minorities an equal playing field. I use the term historic minorities because women are considered a minority, even if they're a majority of the population there. The idea of affirmative action was not that you had to have jobs for women, African Americans, Hispanics, etc. There. The idea was that if everything's equal, that you are to hire the historic minority. So if we had a white woman and a white man that were applying for a job, historically the white man would have an advantage. There. If all things are equal, then the woman should get the job over the man there. That's the idea that you have with it. Problem that you had are some of the businesses, but especially things with government that would end up having quotas. Our Bach case, which we didn't spend a long time on because in the very near future, probably this summer or next summer, there will be some cases that will end up being deeper with this. But for Bach, it has said quotas are not allowed. But it said universities consider race as a factor for admission. So that's where it kind of got a little bit trickier. Again, we're going to have a lot more cases in the near future involving this that may change some of the ideas. One thing that you look at also is reverse discrimination, which was the basis of Bach, where he where he was not accepted into the medical school, but they had set aside for some of the minority groups certain areas. So that's where the idea, that term that you need to know for that. All right, our basis for all civil rights comes down to the 14th Amendment here, and the Equal Protection Clause. And then how sometimes it wasn't applied. Now the Dred Scott case, we did not have it before, so there wasn't anything that was protecting. In Plessy, it said that if it was equal, so that separate but equal doctrine, even though it tends to look to go against the 14th Amendment. For Korematsu, the clear and present danger doctrine, while we were in time of war in here. For other documents, remember Declaration of Independence, something about all men are created equal. I know in one of your argumentative essays, you're going to need to figure out how you put that in there. The basis and scope of government expanding since 1789. I mean, you can kind of look and see the power of government and where they've come into other things. The federal government gets involved in education after Brown versus Board of Education that you have. Another thing you got to look at here is equal opportunity. Okay, it's in here. It's not equality. Equal opportunity is a basis that we have. Communism says everybody's equal. We're not communists, but what we want to make sure is that the opportunity that you have for everybody is. On the upcoming test, if we were equal, you're all getting a 75. But equal opportunity, you all have an opportunity to do the best that you can on this upcoming test that you have. And that's why Brown and Swan were cases that were trying to help with that equal opportunity idea. All right, voting comes into equality. And this is where the expansion of voting has shown the expansion of this idea. The 15th, 19th, 26th Amendment, giving black men, then women, and then people as low as 18 years old that right to vote. The 24th Amendment, any poll taxes. The Voting Rights of 1965 was the third major bill that you need to know. It ended a lot of barriers that were done trying to stop people, especially in the South, from being able to vote, African Americans in particular. One key thing that was part of it, but is now, because of the Shelby case, no longer a part of the side, is preclearance. What preclearance was is if a state was passing a law involving voting in historical places that had discriminated, such as in the Deep South, but there were some other areas also. Then what they would have to do is the Justice Department would have to look at that law. We're going to have a little bit of a reading on Shelby here in the next couple of days in there, which ends it. Notice historically there have been questions that intertwine, and this is where some of the things with civil liberties and civil rights, and where I even said in the beginning, you see there A, describe the difference between civil rights and civil liberties that you have. An older one, when it was more of a true essay, in here dealing with the 15th Amendment, discrimination, but you notice that they start going back to participation. So remember where we have conventional and non-conventional participation in elections as well as in government as a whole.